Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, as you all know that in a criminal case where by the Honorable Court final verdict and judgment has been pronounced, the same cannot be altered, modified or amended court by the court which has passed the order or judgment. That can be alter, modify or amended by a revisional court or appellate court or whichever is the higher court may be. But whether the same principle can apply, whether a civil court after passing a order, judgment and decree can alter, modify or amend the same, if it can so under which provision of law, what is section 152 of the Code of Criminal Civil Procedure, we will discuss in this video. Before I proceed further my video, I would like to request you that if you have not yet subscribed my channel, please subscribe my channel, and if you like my videos, kindly share my videos. Friends, there is a provision under section 152 of the Code of Civil Procedure. What it says, I would like to read. It says, clerical or arithmetical mistake in judgments, decree or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the court either of its own motion or on the application of any of the parties. What does it mean? That while passing the judgment or decree, if any clerical error arises in the judgment and decree, that can be happen. That's a process that typographical error, clerical error, or just slip of mind, that error can arises. Then the question is, at what time? At any time. Whether it can be amended suo motu by the court or upon the application, yes, both the remedies are available. It can be amended suo motu or by the application moved by any of the parties. If what does it mean finally? It means that if a final judgment has been pronounced, a decree has been pronounced, and the parties has obtained the certified copy, and after reading the same, it comes to the knowledge of the court or comes to the knowledge of the either party, plaintiff, defendant, appellant, respondent, that such clerical error, typographical error is there in the judgment or decree or order. It can be modified, amended, altered under section 152 of the Code of Civil Procedure. Now the question arises, how to draft the application under section 152 of c.p.c. So first, if you want to seek correction in the judgment or decree, you have to write the name of the court. Then you have to mention the cause title of the parties. It should be as it is, which is mentioned in the judgment and decree. Then you have to mention the title of the application under section 152 of the Code of Civil Procedure for seeking correction in the judgment or decree, whatever the case may be. Then what should be the contents of the application? You have to start, may it please your lordship, this honorable court has passed the judgment and the decree dated such and such. The certified copy of the judgment and decree is attached with the application. It appears from the after reading of this judgment and decree passed by this honorable court that some clerical error which ought not to have been, that has been done in the judgment or decree, and it is requested, the relief should be sought, that it is requested that if honorable court deems it proper and fit, it should be rectified or modified. Then what the court will do, the court may correct itself or court may issue notice to the opposite party. Generally court used to issue notice to the opposite party so that whatever the alteration, modification or amendment in the judgment or decree will take place in the court proceedings will come to the knowledge of the opposite party. The usual procedure is very simple, that first you have to move an application, a simple court fees is to be paid, then the court will register that application, then the court will issue notice to the opposite party. What documents you are required to file along with this application? You have to file the certified copy of that order, judgment and decree. You have to also file your affidavit. If it is represented by the council, you have to file the wakalatnama, or if it is represented by the party itself, you need to appear yourself and mention all your personal details in the application. Then the court will allow that application if the court will find that it's a merely typographical error or it's a clerical error. Supposingly, something has been mentioned in the judgment, but the other thing has been mentioned in the decree. Take an example that the court has passed a judgment that the defendant is liable to pay 10 lakhs rupees to the plaintiff with interest, but inadvertently, instead of 10 lakhs rupees, it has been typed 1 lakh rupees in the decree. So decree is appealable, not the judgment. So you have to move an application under section 152 of the Code of Civil Procedure. It is very necessary. Otherwise, the appellate court will say that it's a decree against 1 lakh rupees only and not against 10 lakh rupees. So it's very essential and required that you have to move the application. Now the question is arises, in which court the same application has to be moved? The answer is very simple. You have to move application before the same court which has passed the order, judgment and decree. Many times I have been asked by my clients or subscribers, viewers or litigants that whether it can be filed before the appellate court. So 152 is required to be filed before the same court. Suppose civil court has passed the order or judgment, you have to move application before the civil court. If it is passed by the district and session judge court, you have to move before the district and session judge court. If it is passed by the honorable high court, you have to move the application under section 152 of the Code of Civil Procedure before the honorable high court. And it is suggested that you have to also give an advance copy to the opposite court party if it is possible, or you can send an advance copy to the opposite party through a registered post so that it will be convenient to the court as well as to you. Now the question arises, is there any period of limitation for filing section 152 application? The answer is very simple, that there is no period of limitation. As mentioned in the section itself, that court can amend or alter any time. Any time means it may be after 30 days, after 50 days, after 6 months, after 1 year, after 2 year, after 4 year, after 5 year. But what is advisable and what is suggested, that as soon as it comes to the knowledge, the application should be moved. Possibly it should be moved within 30 days. A general principle is that there is no period of limitation is prescribed in CPC. Either the same should be moved within 30 days or at the earliest when it comes to the knowledge of the party. It should not be inordinate delay in filing the application, whether it's section 152 or any section where no period limitation of period is prescribed under the code. Now the question arises, what is the Supreme Court citation? The Supreme Court citation is very relevant. The name is Jayalakshmi versus Oswald. It has been published in Supreme Court cases. The citation is 2001 4 SCC page 181. I would like to read the observations of the Supreme Court. So far legal position is concerned, there would hardly be any doubt about the proposition that in terms of section 152 CPC, any error occurred in the decree on account of arithmetical or clerical error or accidental slip may be rectified by the court. The principle behind the provision is that no party should suffer due to mistake of the court, and whatever is intended by the court while passing the order or decree must be probably reflected therein. What does it mean? That supposedly the clerk of the court done some error in judgment and decree while typing, or a slip of mind by the judge, because honorable judge is also a person, so a slip of mind can be there. So party should not be suffer. This was the intention of the Honorable Supreme Court. So friends, from this video we learned that how the judgment and decree can be modified, which has been passed by the Honorable Civil Court under section 152 of CPC. Thank you friends. Thank you so much.